So in this new act, what would you say were the major changes?
The major changes in this new act is that for the first time, you have an all-encompassing bill that provides for consumer protection, prevents the abuse of a dominant position and monopoly, and also tries to promote competition and regulate mergers and acquisitions all in one document. Now, this is the first time we ever had something like that before. What you had in the past were previous bills dealing with one aspect or the other. For instance, the Investment and Securities Act formerly regulated mergers separately. We had the Consumer Protection Act formerly regulating consumers' affairs. And to be honest, they were not really, none was fully an encompassing document. So now you have something that consumers, investors can look to with respect to these matters.
But how soon will this come into full effect, though?
Interestingly, the Act doesn't have any commencement provision. It commences on the day it was passed into law. Because generally, by law, if you want an Act to commence on a particular day, you state it. If it's not stated, then it's deemed to have commenced when it was passed into law. Now, the implication of this is that you'd ask yourself, what will happen to existing transactions? If measures typically take maybe 6 months to a year, so what will happen to companies that have already begun the measure process? Should they stop? Should they continue? Should they look to the ISA, that's the Investment and Securities Act, or to the new Competition Act? So these are decisions that are really, really, yes.
Yeah, because I'm seeing that this was passed on the 5th of February this year. And in that time period, when you look at M&A activity in Nigeria, we're talking about Access Bank and Diamond Bank. And we saw the letter from the SEC coming in just about last week, giving that final consent. But how does this play out? And does it overlap with other acts as well? Because I know that the Investment and Securities Act has also been in there. Do we have overlapping functions with these acts?
Yes, a bit of overlapping functions with some areas. Now, with respect to the Investment and Securities Act, the SEC will still retain the functions of regulating public companies, but the operations of public companies generally as they affect the public, right? But with respect to mergers and acquisitions, this function has now moved to the commission that will be set up. Now, for existing mergers that had already started their process, the SEC is still handling that. And that's really what is expected. The reasonable thing is that a body has to continue that process. But for new mergers, it's a bit unclear. They can't really file to the SEC. At the same time, the commission is not yet been set up. So what do? Your guess is as good as mine. Some just go ahead and are seeking to just go ahead and carry out their transactions, trying to weigh the risk to see whether they would have been approved under the commissioner. And that's really a very delicate place to be in.
All right, but I'm curious to know how it affects transactions out of Nigeria.
Oh, very much so, because for the first time, you have a clear provision that says that if there's any change, if there's any sale or purchase of assets or shares of a company outside Nigeria, which would affect control of a company in Nigeria, then that comes under the purview of the commission.
But do they make provisions for thresholds?
Well, the threshold provisions have not yet been set. In the legislation, the ISA provided the relevant provisions provided for thresholds. Now, this one provides that the thresholds would be set at a particular date. Now, again, that's a confusing area. But it's expected that, given what this Competition Act seeks to achieve, the threshold would be a reasonable threshold. It should be something more than the 1 billion that currently exists in the SEC rules. There was something a little bit higher than that, considering the inflation rate in Nigeria, the valuation of the Naira, and all those matters. All
right, but I'd like to look at the area of penalties, though, because we're seeing that monetary charges being put in for the first time. Can you speak to this point?
And that's another interesting area, because under the previous, the ISA, the relevant provisions of the ISA provided for just flat penalties. Now, for this time around, the penalties are stiff, more stringent, and almost like saying pay as much as you earn. Because for a company, it will be 10% of your turnover in the previous day. And even directors of those companies, relevant directors, would also be liable to penalties of up to 50 million naira. And then even so individuals too, people operating as maybe partnerships, for instance, or there are also penalties. So for the first time, this is a bill an act that you cannot ignore. You can't ignore it if you're trying to invest in Nigeria through an acquisition of shares, or maybe a company in Mauritius, the BVI, any of those jurisdictions. You can't ignore it, as long as it's going to affect control of a company in Nigeria affect ownership. Yeah, you have to look at it.
The government has been trying to do quite a lot around the ease of doing business. But do you think this adds like another regulatory burden, you know, this act coming into full effect?
Well, in a way, it's a burden to the extent that companies, investors that would usually seeking to invest in Nigeria would just merely probably acquire the shares of a holding company in maybe a place like Mauritius, would now need to step back. They have to call their lawyer on board and say, could you review this and make sure that I have if I have implications, what do I do? So yeah, it's going to put a bit of it's slowing down the process, but in a way, it's also a necessary step that needs to be taken in order to protect the rights of consumers and also promote competition in Nigeria as a whole.
Right, but do you think this would have impacted the outlook of M&A transactions in 2019?
Yes, it definitely does have an impact.
But how much then? How do you think it do?
It's significant to the extent that potential M&As may need to wait until the commission is set up, especially if they know that what they're about to do, they are likely to maybe flout the competition laws. For instance, if two juice makers are about to merge and they have major market share, for instance, they probably need to wait and see what the Competition Commission approve that transaction. It's something they need to think about. There are some transactions that they can easily, some companies, for instance, can easily look at the threshold of the business and decide that I think this is something that would not even be considered by the Competition Commission. So yes, it's really going to it's an ambiguous position right now until the commission is set up.
All right, we'll wait and see when the commission is set up, and then we'll take things forward from there. Thank you so much for joining me on the show. I've been speaking to Ogochukwu Isiadinso. She's an Associate Director for Tax and Advisory Services at Andersen Tax.